A very good morning to you and welcome to Courtroom 1 of the Supreme Court. We are awaiting the sentencing in the matter of the King against Julian Silvera. The Chief Justice is standing by and is about to begin his address to the courtroom. Thank you very much for joining us this morning. We are going to begin now.
Okay, these are the sentencing remarks in the matter of the King against Julian Silvera, charged on an indictment containing 2 counts. Count 1 charges him with the offense of using a firearm to commit a felony, contrary to Section 14.2 or Section 14 subsection 2 of the Firearms Prohibition, Restriction, and Regulation Act. The particulars of that offense are that Julian Silvera, between the night of November 10, 2023, and the morning of November 11, 2023, in the parish of St. Andrew, used a firearm to commit a felony. Initially, the felony was murder. It was changed to manslaughter, and he pleaded guilty to that offense. Count 2, charge him with the offense of murder. Particulars of that offense are that Julian Silvera, between the night of November 10, 2023, and the morning of November 11, 2023, in the parish of St. Andrew, murdered Melissa Silvera. To that count, he entered a plea of not guilty of murder, but guilty of manslaughter. The plea was accepted by the prosecution and accepted by the court. This plea was entered on February 3, 2026. And on that date, a statement from the defendant was read into the record. And it states, I, Julian Silvera, made this statement to say that on the night of November 10th, 2023, a very unfortunate incident occurred, resulting in the death of my wife, Melissa Walter Silvera. Leading up to that event, there has been provocation from her ever since the death of my son, for which she continues to blame me. As per usual, to avoid confrontation, these confrontations vary from financial to taking responsibility for the conditions that we were living in, and she has a time where she explodes no matter when and where. She became very physical that particular night. These are ongoing things. So at times, when I see that this is going to blow out of proportion, I normally take refuge, at my sister's house to allow her temper to quell. On this particular night, the rhetoric began. She became more confrontational than normal, screaming, shouting, and even at times swinging her fist. So I decided that it was time to leave. So I reached for my gun, where it is normally kept, to holster it, and told her that I would be back tomorrow. She became increasingly angered and enraged, and lunged after me and grabbed at the gun, and then uttered the words to the effect that I was responsible for the death of our child, and made derogatory comments about my mother and the family. Although she had mentioned blaming me for the death of my son before that night, the way she said it and how, and the mention of my mom and my other family, her words and expletives that night really angered me in the moment. Melissa told me I must stop fucking my sister, because every night I'm always going to my sister's house, and a sister can't do what a wife can do. She said that my mother was a selfish fucking bitch, and maybe I should go and fuck her too. These words provoked me, and her final comments were to fling the rest of the picnic them into the pool and kill them too. With all of these words, I lost control and fired. It was never my intention to do this. It was not premeditated, and it was not my intention to hurt or kill her that night. This having happened, I panicked and I left. Over the course of the next few days, I thought about my children losing two parents, and thought it best not to admit, because I wanted to be there for them. And importantly, this statement, which I read over, consisting of what? One page, signed by me, Julian Silvera, is made of my own account. And it went on to indicate that it bore his signature and date, and a witness who was not connected to the matter. So what we have then is a written statement in which he outlined in some detail the circumstances that unfolded on that unfortunate evening. Now let us go now to what the prosecution outlined to the court. And then we'll have some observations about that, and then put this in context of the law relating to homicide. Prosecution's narrative is this. Sometime after 10:30 p.m. on the 10th of November 2023, Mr. Silvera told his wife and children that he was leaving and that he will return the following day. His wife told him that he could not leave, and an argument ensued. According to the children, the adults swore at each other, and then he left. Sometime before 6 a.m. on the morning of the 11th of November 2023, one of the children, and the name is there, but I'm not calling the name, went into his parents' room, he discovered his mother's lifeless body on the floor next to her bed. He observed that blood was coming through, to quote, her butt, mouth, and nose. He ran from the bedroom and alerted his other brother, who accompanied him back to the parents' room. They indicated they both checked for signs of life. They then decided to make contact with their father and were eventually successful. The prosecution next referred to a witness statement provided by Mr. Silvera. This is a statement that was provided before he became a suspect. In that statement, he indicated that upon speaking to his children, he contacted the Stony Hill police station and told them that he was on his way home when he got a call from his son indicating that his mother's lifeless body was there and that he needed assistance. Upon arrival at the house at 2A Diamond Road, Stony Hill, in the parish of St. Andrew, Mr. Silvera went into his bedroom, saw his wife sitting in a position with her head leaning forward at the side of the bed. According to witnesses, that is the children who were there, he touched her, spoke to her, and found that she was not responding. So up to that point, based upon this, you had the body, the children, then Mr. Silvera arriving, then you had Mr. Silvera, the body, and the children. Short while after, a first responder from the Jamaica Constabulary Force arrived, that is a sergeant from the Stony Hill police station. He went into the bedroom along with Mr. Silvera, where he, the police officer, saw the body of the deceased. The police officer described the body as being on her knees in a crouching position with her face lying on the floor. The police officer then took a photograph of the body, and whilst he did so, he says Mr. Silvera cried out. He told Mr. Silvera to cover the nude section of his wife's body. The police officer did not carry out any further examination of the body. The officer indicates that he did not, that Mr. Silvera advised him that the deceased had no known medical condition, and the police officer seems to be indicating that a post-mortem examination would be conducted to determine the cause of death. The House of Tranquility Funeral Home was contacted for the removal of the deceased body. Not clear from the narrative who did the contacting, but nonetheless, that was a contact that was made. The police officer says he then indicated that he told Mr. Silvera, do not do anything to the bedroom pending the post-mortem examination, as the cause of death was undetermined. Mrs. Silvera's body was removed and taken to the Tranquility House of Tranquility Funeral Home. A post-mortem examination was scheduled for the 1st of December 2023. The pathologist who arrived to do the post-mortem examination observed marks on the body. As a result of her observation, the body was sealed and the detectives were called to assist in the investigation. So, on the 15th of December 2023, the same pathologist conducted post-mortem examination on the body of Mrs. Silvera. The pathologist noted that there were 3 gunshot wounds, 1 perforating gunshot wound to the front right thigh, 1 penetrating gunshot wound to the left side of the lower abdomen, and a 3rd that is described as a superficial penetrating gunshot wound to the right side of the lower abdomen. The pathologist found that the immediate cause of death was due to multiple gunshot wounds. During the post-mortem, the pathologist removed 2 projectiles from the body of Mrs. Silvera. These projectiles were handed over to an officer, not the one who turned up apparently on the 10th of November, assigned to the Jamaica Constabulary Force, and it was after the post-mortem was concluded, Mr. Silvera became a suspect and was taken into custody. The narrative goes on to indicate that he's a licensed firearm holder. Specifically, he has a 9mm Glock Model 17 Gen 4 double action auto-loading pistol black polymer receiver slide, a 17 cartridge capacity magazine bearing the serial number AAFZ038, and this firearm was taken from him. The firearm was submitted to the Institute of Forensic Science and Legal Medicine for ballistic testing, along with the 2 projectiles removed from the body of the deceased. The ballistic examiner made a comparison. He test-fired the gun. This is now in January of 2024. Test-fired the gun. He took results from those test fires of January 2024 and compared it to the projectiles that were removed from the deceased body. He found what he called level 1 characteristics matching. That is, according to the narrative, the projectile came from a Glock pistol, the type of Glock that it would have come from. He found that there was some amount of level 2 matching, and this apparently is striations, and that there were no additional markings that were unusual. So I'll pause here for a moment and indicate this. In preparing for this matter, I was reading through the material, and I had sent questions to both counsel for the Crown and the defense through the Registrar of the Supreme Court to answer specific questions. I had used the incorrect expression. I think I used markings, level 1 markings are not matching. So counsel for the defense, being the cautious man that he is, he indicated that he did not have any document that referred to level 1 or level 2 markings. So that was my error. They should have been matching. The Crown also responded, getting assistance from Superintendent of Police Miguel Bernard, and he responded, and apparently this is a quotation from him. I don't think the defense is taking issue with the exposition on this by the superintendent. He says, correcting me, that the term used was level 1 matching and level 2 matching. The term is used to provide a simplified understanding of the examination process. Level 1 matching, this is matching of the class characteristics. Class characteristics can be used to eliminate certain firearms as potential sources of firing a bullet or a cartridge case. However, they do not narrow it down to one specific firearm in the class or group. Class characteristics of bullet include the caliber, the number of lands and grooves, direction of twist of lands and grooves, and width of the lands and grooves. It says in this case of the King against Julian Silvera, the class characteristics narrowed the source of the marks on the bullet to Glock pistols, which is a smaller group from all the potential make of firearms that exist. The accused firearm submitted as evidence in the case was a Glock pistol. Therefore, the examination progressed to level 2 examination. So what he seems to be saying is that the level 1 determines the class. And then once it falls, you identify the class, then you go on now to see about the specifics of the object, the gun. Level 2 matching, he says, is this. This is matching of the individual characteristics that are unique to one specific firearm. At this level, the comparison requires microscopic analysis and cannot be done with the naked eye. Individual characteristics of bullets are random, striated marks, striations on the land impressions on the bullets. In this case, the King against Julian Silvera, there was sufficient matching of the individual characteristics to conclude that the bullets matched the test fires said to be from the accused's licensed firearm. He says The damage seen in the barrel was consistent with a corrosive chemical reaction in the barrel, was unlikely to have occurred naturally because in the relatively short space of time between the death of the deceased Melissa Silvera and the gun being submitted to the ballistics department, this corrosion distorted the individual characteristics, making it difficult to match bullets fired through the barrel before the corrosion and those that were fired through the barrel after the corrosion. That is to say, the damage was consistent with or likely a deliberate attempt to prevent any subsequent matching of test fires from the gun with any bullets that were fired through the barrel prior to the corrosion. So we go back now to the narrative here. Yes, so he continues now. There is something called an IBIS system, that is an integrated ballistic identification system, commonly known as IBIS. This is a database, and this database contains firearm ballistic signatures. So how does this come about? Under the Firearm Prohibition, Restriction and Regulation Act that came into effect in 2022, roughly a year before this incident, Section 20 of the legislation sets out the responsibilities of what is called the Firearm Licensing Authority. Section 20, subsection 1 says, there shall be established for the purposes of this act a body to be known as the Firearm Licensing Authority, which shall be a body corporate to which Section 28 of the Interpretation Act applies. Section 20, subsection 3 states, the authority shall be responsible for regulating, in accordance with this act, the handling of firearms and ammunition, and the importation and exportation of firearms and ammunition into or from Jamaica, and without prejudice to the generality of the foregoing, the functions of the authority shall include, and it has an impressively long list, but for our purposes now, we come to paragraph L, which says that that is the Firearm Licensing Authority to conduct ballistic testing, capturing ballistic signatures in relation to privately owned firearms, and capturing related information with respect to firearms that are the subject of authorizations granted by the board. Then there is reference to Section 29, which speaks to the identification of firearms. And then there is Section 31, which says the institute shall be the responsible entity for capturing ballistic signatures and other information in relation to firearms that are the property of the government of Jamaica. And then Section 31, subsection 2 says the authority shall be the responsible entity for capturing ballistic signatures and other information relating to privately owned firearms. So that is the context in which this capturing of signatures of firearms take place. An institute is defined in the legislation as the Institute of Forensic Science and Legal Medicine. That's found in Section 2, that's the interpretation section of the statute that defines institute. So that is what is being referred to in the legislation at Section 31. Right, so now, so the narrative goes on. The Firearm Licensing Authority apparently has access to this IBIS database. And apparently the idea is that whenever a person would acquire a firearm that's a private citizen and present the firearm to the Firearm Licensing Authority, test fires will be made and the ballistic signature from the said firearm is uploaded to the IBIS system. So the FLA creates a signature, is stored on the IBIS system. The expert goes on to say now that in January 2024, he took the test fires from Mr. Silvera's firearm and compared it to the ballistic signature that the FLA would have had based upon its statutory powers. And he also compared the projectiles taken from the body of the deceased to the ballistic signature of Mr. Silvera's firearm containing on the IBIS database, and he got a match. This led him now to do a physical examination of the ballistic material. So the expert contacted the Firearm Licensing Authority and requested the physical ballistic material belonging to Mr. Silvera's Glock pistol. The FLA provided the material to the Institute of Forensic Science and Legal Medicine. The expert did a comparison, And the spent casings in the FLA's possession that came from Mr. Silvera's firearm was compared against the projectiles, that is the bullets, taken from the body of the deceased, and it was a match. He went further. He did a comparison as well between the spent casing, that is the ballistic material from the FLA, to the test fires that he, the ballistic expert, did of Mr. Silvera's firearm in January of 2024, and arrived at the same conclusion. That is, he saw level 1 matching and some amount of level 2 matching. The expert goes on to say, according to the Crown, having looked at the barrel of the firearm closely, he saw what in his opinion would have been the existence of corrosion or the existence of a corrosive material being introduced into the barrel of the firearm. But based on the extent of the level 2 matching of the characteristics, he was able to say that these projectiles came from this firearm. Now, additional narrative here. The Crown outlined that each time an individual renews his or her license for the firearm, the authority itself would take the firearm and inspect it for modifications or any signs of tampering. The narrative from the Crown is that on the 29th of September 2023, Mr. Silvera renewed his license and the firearm was inspected on that day. The information from the Firearm Licensing Authority is that no signs of tampering were observed during that inspection. And then, after the conclusion of the ballistic examination, no surprises here, Mr. Silvera was taken into custody. I think he was already in custody before based upon the narrative, but anyway, he was now arrested and charged. The expert expressed the view that the corrosion could not have occurred naturally based on what he saw. In fact, he said that that type of corrosion would normally occur in firearms that are kept in water, or firearms that are buried in some areas as frequented by liquid or some other form of substance. He expressed a view that it could not have occurred between the 29th of September 2023, when the firearm was examined by the Firearm Licensing Authority, and January 2024, when he, the expert, did his examination. So he was then, that is Mr. Silvera, arrested, charged for the offenses of using a firearm to commit a felony and murder. And after that narrative was outlined, then the Crown indicated that they were minded to accept the plea. So that's part one of my remarks. So now, let us put things in perspective. The legislation that governs offenses of this nature is the Offenses Against the Person Act. At Section 6, it says, and I am missing the first few letters here. So let's find one with all the information present. Section 6 says, where on a charge of murder, there is evidence on which the jury can find that the person charged was provoked, whether by things done or by things said, or by both together, to lose his self-control, the question whether the provocation was enough to make a reasonable man do as he did shall be left to be determined by the jury, and in determining that question, the jury shall take into account everything done and said according to the effect which, in their opinion, it would have on a reasonable man. You have to forgive the gender of the language, but that was the language of the statute at the time. It applies to both men and women. So the point is that what Mr. Silvera outlined in his statement, had it gone to trial, would have to be put to the jury for them to consider whether he is not guilty of murder, but guilty of manslaughter. And let us not forget that in the context of a trial, the jury, in its wisdom, can acquit completely, because we seem to forget at times that juries don't have to accept any fact that is put to them. They are constantly reminded of this. So a jury, if they analyze the evidence and they conclude that no offense was committed, then they are duty-bound to return a verdict of not guilty, because at that point, the only opinion that counts is theirs, not the judges, not counsel for the defense, not counsel for the prosecution. So, having regard to what is in his statement, though he was indicted for murder, the question of manslaughter would have to be left for the consideration of the jury, and they would have been told, among other things, that they cannot convict of murder unless they are sure that provocation or lack of intent or any other factor that will reduce it to manslaughter didn't arise on the case. So now, let us put this in perspective. So manslaughter is best understood if it is seen in the context of homicide. And homicide is a generic term, killing of one human being by another. And in our criminal justice system, homicides are classified as either murder or manslaughter. And I'm excluding, for the purposes of this, death caused by reckless or dangerous driving. So, murder occurs when a person of sound mind and discretion, by a voluntary and deliberate act, causes the death of another who is under the sovereign's peace in circumstances where the person doing the act causing death had the intention to kill or cause really serious bodily harm, and while doing the act which causes death, there was no lawful justification, such as self-defense, or excuse, such as insanity, and so on. Now, manslaughter falls into two categories: voluntary and involuntary manslaughter. In voluntary manslaughter, all the ingredients of murder are present and would be murder but for the presence of a partial defense, such as provocation or diminished responsibility. It is voluntary manslaughter because the act which causes death was done deliberately, with the intention to kill, and would be murder had it not been for the presence of the partial defense. Involuntary manslaughter is so called because of the absence of an intent to kill or to cause really serious bodily harm. So into this category you find things such as unlawful and dangerous acts. You might push over someone or you punch someone in the face and they drop and hit the head and they die. Oftentimes in that context the person doing the punching does not intend to kill or to cause any really serious injury, but it's an unlawful act. So that is the distinction really. And what is the significance of the distinction? It is now reflected in the approach to sentencing. So, manslaughter arising by a provocation or by diminished responsibility, category into the category of voluntary manslaughter. Manslaughter arising from an unlawful and dangerous act or by gross negligence, involuntary manslaughter. In the case here, we are not dealing with involuntary manslaughter, but voluntary manslaughter. I make reference at this point to the Social Inquiry report, where the defendant was interviewed, and this is what he indicated to the probation officer. Said Mr. Julian Silvera was interviewed at the Kingston Central Police lockups. During the interview, he was respectful and cooperative. He stated that for several years prior to the incident, he and his late wife frequently argued, primarily over financial matters. He further disclosed that he was blamed for the death of their son, which further contributed to ongoing tension in the relationship. On the day of the incident, Mr. Silvera reported that an argument occurred between him and his wife. He explained that it was customary for him to leave and spend the night at his sister's residence following disputes. However, during this particular argument, his wife spat in his face and accused him of engaging in incestuous relationships with his older children and his sister. Mr. Silvera stated that during the confrontation, he reached a breaking point. He went to retrieve his licensed firearm to holster it, and as his wife approached him, the situation escalated further, and in the course of the struggle, he discharged the weapon 3 times, fatally wounding her. He admitted that he panicked immediately afterward and left the apartment. He emphasized that the incident was not premeditated, but rather the result of provocation in the heat of the moment. Mr. Silvera expressed deep remorse, stating that he is profoundly regretful that such a tragedy occurred. He acknowledged that there will be consequences to face, but he hopes that one day he will be able to meet his children again to seek their forgiveness. So, Mr. Silvera further explained that no professional intervention was ever sought during the course of their marriage, their marital difficulties. He described his late wife as someone who would escalate quickly during disagreements, going from 0 to 100 in no time. He stated that he often encouraged her to undergo an assessment to determine whether she might have been suffering from a mental health condition such as bipolar disorder. He added that matters worsened following the death of her mother, after which, quoting now, everything that could go wrong went wrong, unquote. And he noted that his wife did not cope well with her mother's passing. So, again, had the matter gone to trial and this information was presented as a part of this case, the question of provocation would have had to have been left for the consideration of the jury. Now, I'll go back to an earlier part of the prosecution narrative before, well, not so much the narrative, but remarks made by prosecuting counsel before getting into the details of the narrative for this specific night. The prosecution did indicate that there was information available to them from someone who had known Mrs. Silvera for a considerable period of time. And that person and Mrs. Silvera would have what she calls tracing, and by tracing, she said she meant to make up some noise. The prosecution also had information that Mr. and Mrs. Silvera would often have arguments, but they would call and make up later. And even in that context, the deceased would still push her point. She was very determined and excellent, according to this individual. Indicate that she was a loving mother to her children. And the prosecution also had information that Mrs. Silvera was very mouthy, and what was meant by that she was feisty and a strong-willed woman who was very smart. So that was information that the prosecution had in its possession, which they indicated to the court. And so that is part of the context now in which the plea for manslaughter to manslaughter was considered by the court. And certainly, in my view, what Mr. Silvera indicated as to how the argument developed is not inconsistent with what these other persons are saying. This is not a question of maligning the dead, but it is what it is. And the information is from persons who are, or some of, at least two of them are friends of the deceased woman and who knew her apparently quite well. So that is the additional information and context here. Now, I'm going further now into the sentencing process. This is now part 3. Sentencing is a complex process. It is a multi-layered and multi-factored process. There are factors relating to the offense itself which must be considered, and matters relating to the offender, and both interact, and that interaction assists in determining the appropriate sentence. It has also been said that sentencing courts must keep in mind what has been described as the 4 classical principles of sentencing: retribution, deterrence, prevention, rehabilitation. The authorities indicate that the court also needs to keep in mind the character and antecedents of the offender. So, in other words, even if you are dealing with similar offenses, the sentences may not end up to be the same mathematically, because there may be factors that are peculiar to one defendant that do not apply to another defendant, even in the same case if they are convicted for the same offense. The level of participation and culpability may very well vary. So it is not surprising then in some murder cases, several persons can be convicted, but one person may be an accessory before the fact, another may be the one who did the act that caused death, and so on. So you have the variations there. Now, for voluntary manslaughter, which is what we are dealing with here, it usually attracts a custodial sentence, and the custodial sentence frequently, not invariably, frequently is higher than the sentence for involuntary manslaughter, if for no other reason that voluntary manslaughter is closer to murder in the criminal calendar. So that is how the reasoning goes. Remember that voluntary manslaughter involves an intention to kill or cause serious bodily harm and would be murder but for the presence of the partial defense, as in this case of provocation. It is also a serious violation of the victim's right to life. And so, for those reasons, it attracts a custodial sentence. The Criminal Justice Reform Act tells us that the judge should proceed in a manner to consider whether a non-custodial sentence is appropriate, but the same act excludes firearm offenses, and even if that statute had not been in existence, the general approach of the courts has been to impose a custodial sentence in cases of voluntary manslaughter. So we are getting closer, not yet there, but we are getting closer. So we now come to how sentencing is actually done. So since 2017, we have had sentencing guidelines. And I emphasize guidelines. It's not a statute. It's a guide. What is the purpose of the guide? The purpose of the guide is to establish a consistent methodology to the question of sentencing. It is not designed to produce mathematical equality. It's not what it's designed to do. So when you come to look at aggravating factors, there is no such thing as this aggravating factor equals 2 years, this other aggravating factor equals 6 years, this other one equals 0, this one is 10, and the mitigating factor, if this is present, it comes down by 6 months, it comes down by 10 years, and so on and so forth. It is designed to guide the thought process of the sentencer, who should articulate how he or she went about the sentencing process. So in the event, well, firstly, the defendant would need to know why he got the sentence that he did. Let's start there. Persons who may be connected in this case to the deceased would need to know how did the judge get here, even if they disagree with the judge and they go outside muttering afterwards that this judge is a real fool. But they would still be clear as to the process, as to how the judge got there. And also, in the event of an appeal, the appellate court would have the advantage of seeing the thought processes of the judge to determine whether the methodology and the approach is in keeping with established principles. So we have the case of the Queen against Misha Clement. That has been the cornerstone of our sentencing practice. In that case, the late President of the Court of Appeal, the Honorable Mr. Justice Dennis Morrison, referred to the Trinidad and Tobago case of Aguilera and the state. And for those who are really interested in this, it's found at 89 West Indian Reports at page 451. And in that case, or rather Justice Morrison referred to that case with respect and admiration. And he suggested that that case had adopted a more nuanced approach to the fixing of the starting point, because this is the anchor point in sentencing cases. What is the starting point? How do you get there? What principles go into establishing the starting point? So Trinidad was having the same issues that we were, some would say still are, having. And the Trinidad Court of Appeal looked at New Zealand and looked at other jurisdictions as well to deal with this question of a starting point. And after the examination was done, the Trinidad Court of Appeal decided that the starting point is defined in this way. That is the sentence considered appropriate for the particular offense of an adult offender after a contested trial. And that is the definition that I'll be using in this case to establish a starting point. Remember, it's just a start. The other thing is this, that this way of approaching sentencing, this method, this new methodology, is different from what was called politely the synthesized approach or the instinctive approach to sentencing, where the judge just simply heard from counsel and then said, well, I think it is worth 15 years, and that was the end of that. Nobody knew what the considerations were. That is now considered to be inappropriate in modern sentencing practice. But one of the sticking points has been the starting point. How is it defined? How do you establish it? And so the Trinidad and Tobago has contributed, at least to my understanding, by saying it is the sentence considered appropriate for the particular offense, an adult offender, after a contested trial. So immediately, since it's a starting point, it is rare that it is going to remain there. The approach of the Court of Appeal of Trinidad and Tobago, similar but not identical to that of England and Wales, and also the Cayman Islands, where they seek to establish as well a starting point. And what I'm going to do is to indicate that using the Trinidadian definition of a starting point, going to indicate now what goes into the considerations to establish the starting point. And then here I'm going to be using the terminology from the Court of Appeal of the Cayman Islands, where they use the language of harm and culpability. What do they mean by harm? It refers to the result. What happened? How bad is the result? What actually happened? It asks as well, what could have happened? And culpability looks at the blameworthiness of the offender. So it looks, was it deliberate? Was it spontaneous? Was it premeditated? Those are the things that go into establishing the starting point. Now there's something that is also a bit more controversial, and it has to do with how firearms are looked at. And here I must recognize the contribution of my judicial counsel, Mr. Blackwin, or Shane Blackwin, who has been very helpful in doing the research in this matter. And in looking at the cases here from our Court of Appeal, there don't seem to be very many cases that seem to treat with firearm homicides as a unique or separate and distinct class. Other jurisdictions have done so. So one says the use of a firearm, they say you start high. Why? Because it results in a death. And then now, so that's on the quote-unquote objective side of it. And then on the subjective side now, you look at the, was it premeditated, was it spontaneous, and so on, to get a sense of where you should start. The other thing too is that the harm culpability approach refined in the Cayman Islands establishes categories. So within, for example, the offense of murder, you might have 3 or 4 categories, and each category has its own band. So for the offense of murder, you may find 4 bands. Band 1, this is the range of sentencing. Band 2, this is the range of sentencing. Band 3, this is the range of sentencing. They have also done the same for manslaughter, and they have broken it down now into manslaughter by provocation, manslaughter by diminished responsibility, manslaughter arising from an unlawful and dangerous act. And within each of those categories, you have bands within them. So again, it's not a one-size-fits-all, because the idea is, while you recognize the seriousness of the offense, you also have to take into account the offender before the court to arrive at what is considered to be the appropriate sentence. So that is the approach that I'll be taking. And then when the starting point is established, then you look more closely at the aggravating, mitigating factors in this particular case. Then the next stage is to take account of things such as guilty pleas, previous behavior, good character, all of those things, and then you arrive at a final figure. So that's really the methodology. So from the research done, in Trinidad, as here, the maximum penalty for manslaughter is life imprisonment. One of the principles of sentencing is that maximum penalties are reserved for the worst of the worst, however defined. Some person may be wondering, well, how do you ever get there? Well, it's on a case-by-case basis. Some people are annoyed with that definition or approach, but there it is. So it is reserved for the worst of the worst. And the Court of Appeal of Trinidad and Tobago reminded us that even if the judge thinks that the penalties are low, the judge can't take it upon himself to say, well, in light of these low penalties, I am going to use the maximum as a starting point, because that is not the way it is to be done. So it is going to be very, very rare that the starting point is the maximum penalty in a manslaughter case. Notwithstanding that, the Court of Appeal in Trinidad and Tobago they seem to operate in the range of 15 to 25 years for serious manslaughter. With regard to firearms, they give that special emphasis because, in their view, firearms are inherently lethal and create significant risk to the public. And accordingly, offenses involving firearms in the Republic of Trinidad and Tobago are routinely placed towards the upper end of the manslaughter spectrum. And one case, Puran and the state, the court went as far as saying that where a firearm is deliberately discharged, substantial custodial sentences are justified, notwithstanding the presence of mitigating factors such as provocation or good character. In the Bahamas, that Court of Appeal there, they have identified a range of 18 to 35 years for serious cases of manslaughter. And they are of the view that manslaughter cases involving the use of a firearm should be to the upper end of the manslaughter spectrum. So too in Belize and also the Eastern Caribbean Supreme Court. So the sentencing methodology is not identical across those jurisdictions, but what seems to unite them is that firearm offenses are treated seriously and it elevates the starting point. Now, so I'm saying all of this to say that I'm not of the view that we're in Jamaica where we say that the range is from 3 to 15 is applicable here, since we did not and have not yet treated with firearm offenses in the way that other jurisdictions have. So, since we are dealing with voluntary manslaughter, it is the case that then it's a voluntary and deliberate act. And Mr. Silvera is not claiming that the gun went off. He's acknowledging that he shot her, but he's saying there was a presence of provocative words and actions. I also take account of the fact that certainly okay. We're going to pause a moment here, and I'm going to say this, so listen carefully now. No one is to have a cell phone or electronic device in their hands other than myself and counsel involved in the case. And the journalists. No picture taking is to be done. So if you don't have it in your hands, the temptation is reduced considerably. Or better yet, switch them off. So no picture taking. Okay? Yes. So, as I was saying, that our approach, as in Jamaica, has not yet gotten to the point of Aguilera, what they've done in the Cayman Islands and so on. But nonetheless, let us make a start. This case is also taking place in a particular context. What is the context? That Parliament has indicated through the Firearms Prohibition, Restriction and Regulation Act that the use of firearms to commit crime, whether licensed or unlicensed, is a very serious matter, and they repealed the old legislation and gave enhanced penalties. Now, we have a range, as I said, from 3 to 15. So it would be quite a remarkable thing to me if persons who commit non-fatal offenses with a firearm could end up with a higher sentence than a person who has committed a fatal offense with a firearm. So something just seems wrong about that. And so it is my view that in the present climate, reflected by legislative changes in other areas, homicide with a firearm could not be within the 3 to 15 range. It has to be higher than that. The other incongruity, it would appear to me, is this. The offense in count 1 charges the offense of using a firearm to commit a felony. Now, murder and manslaughter are not the only felonies that exist. Robberies are felonies. So again, you'd have the incongruous situation where a man who commits a firearm offense, in this case robbery, he may end up a longer time in prison because of the mandatory minimum, a longer time in prison than a person who has taken a life. So, that being the case, and having regard to what has been happening in other jurisdictions, how they have approached it, when you look at the harm, a death. A violation of the person's right to life. Regardless of how provocative they may have been, the fact is they have the right to life. And even persons on death row have the right to life. That is why the sentence is pronounced as to suffer death in the manner prescribed by law. So you can't have somebody running off the street and going on to death row and say, well, look here, man. Since you have been sentenced to death already, I'm going to save the hangman some trouble, and I'm going to kill you myself. So that wouldn't be death in the manner prescribed by law. So it was a deliberate killing, because that's what voluntary manslaughter is. And so in my view, a starting point should really be, in this case, about 25 years. So that is where I anchor the starting point. That is in respect of count 2. The harm was significant, and the culpability, in this case, the offender, is the principal in the first degree. It was his act that caused the death, and it was a deliberate and voluntary act. And that is also in the context of the movement to raise the levels of sentencing applicable to murder. So in my view, there should be a clear distinction between manslaughter and murder and wounding with intent. Yes, a very serious wounding with intent will maybe overlap with lower culpability manslaughter. A manslaughter sentence at the higher end may overlap a little bit with the lower end for murder, but nonetheless, the distinction between the offenses should be maintained, and offenses that involve a homicide should always be regarded as a class apart from any other sentence, if for no other reason that the victim's, the deceased's right to life has been violated in a fundamental way, and it is an irreversible state of affairs. Then now, having established this anchor point, the starting point that reflects the gravity of the offense itself, reflecting its seriousness, the degree of harm, the level of culpability of the offender, then we go on to the next stage now of whether there should be upward or downward adjustment. And just to make the point that when you're dealing with upward adjustment as a result of aggravating factors, downward adjustment, mitigating factors. Now, it doesn't mean that in every case there's going to be an aggravating factor or mitigating. So the judge is not to manufacture aggravating and mitigating factors. If none exist outside the commission of the offense, then that is it. So the judge can't go squeezing and torturing the evidence to find an aggravating or mitigating factor. Now, in this case, we have had submissions from counsel on both sides, and I thank them for their assistance. I mean, I really thank them, not saying it because there's something to be said. So, I've also had the character witnesses as well, coming in from the defense. The Crown is emphasizing these factors that it says are aggravating factors. That is, Mr. Silvera would have known what happened. the Crown is also suggesting that Mr. Silvera has been before the court since 2024, early 2024, January 2024. So what he's saying is not really anything new, because he would have known about the argument in the bedroom. He would have known that he was the one who actually shot her. He would have known that she was either dead or dying when he left, and there is no evidence that he sought any assistance from anyone. You know, there's an accident at my home, please come. It was the discovery of the body by the children and the call based upon the narrative that brought him back to the house. So the Crown's position seems to be that he should not receive any discount because of the guilty plea, or very little because of the timing. And then, so we'll see what we make of that at the appropriate time. But that's the argument as I understand it. There's also a statute that regulates or has some assistance, provides some assistance here. This is the Criminal Justice Administration Amendment Act of 2015, and Part 1A speaks of reduction of sentence on guilty pleas, and in particular, it speaks to first relevant date, which means the first date at which a defendant who is represented by an attorney at law or who elects not to be represented by an attorney at law is brought before the court after the judge or magistrate, and this is the critical part now, is satisfied that the prosecution has made adequate, not complete, adequate disclosure to the defendant of the case against him in respect of the charge for which he is before the court. So the whole idea there of the legislation is that it is not the first day that you appear before the court, but what information did you have from the prosecution that would enable you to make an informed decision. And so the prosecution's argument is that disclosure was made in early January. Post-mortem examination was served as well. So they are saying, separate and apart from what he knew, he also had information that outlined that it was his firearm that caused death of this person. And so the prosecution is suggesting then that the delay in entering a plea was, my words now, not theirs, playing the odds. Let us go along, see what happens, and then I will make a decision. So the prosecution is suggesting that this was a tactical move on the part of the defendant. And so the prosecution is suggesting then that this guilty plea, helpful as it is, should not, Mr. Silvera should not benefit from the generosity of the statute to the fullest extent. Well, we'll see what to make of that at the appropriate time, but the cases do indicate that a guilty plea is of value. What is the value? One, it minimizes, well, it removes the trauma of witnesses having to testify. It frees up resources so that it can be dedicated to other cases, and the person has accepted responsibility. So if for no other reason, then it should be recognized as a mitigating factor. So we have to weigh all of that. So in my view, in looking at this matter, what are the aggravating features? This is a killing in the context of a domestic setting. Mrs. Silvera was in her house. It is a place that she was entitled to feel that she could be safe, or at least not shot and killed. And the children have been deprived of a mother. So those are aggravating features. Another, to me, aggravating feature, because the narrative of the Crown didn't indicate whether death was instantaneous or she was alive for some time. It wasn't clear on the narrative. But it means that if she didn't die immediately, then she would have been left there to succumb to her injuries. If she died immediately, based upon the narrative, these two youngsters, very young gentlemen, would have, as children normally do, you get up and you go into your parents' room. That's what children normally do, to stumble upon this there and leaving the children to make that discovery with no support. No, there's no evidence that any other adult was at the property. And so they did what children do, you call the other parent. And then, when he came, pretending that he was just as surprised as anyone else about the death of Mrs. Silvera. All of these, to me, are aggravating circumstances. In addition to that, let me get back to the narrative here outlined by the Crown in respect of the ballistic evidence. because it was the ballistic evidence that anchored Mr. Silvera to the crime. Because there's no report that the firearm was missing. No report that it was mislaid. No report that it was stolen. And his initial response to the police granted, I will accept that the police officer had a responsibility. You can't be there being taken in by all of this. You go and you see a body. As a police officer, you're not a pathologist, but at the very least, you should be saying, don't touch the body. Call the crime scene persons. Let us see what happened here. So I wouldn't expect the police officer to be going over there pretending as if he's a forensic pathologist. But the police officer, being, I suppose, misguided sympathy here, was being taken in by the act of Mr. Silvera, to the extent that the police officer now, rather than doing his duty, he is now treating this as if it's just an unexpected death that may have been by a heart attack or some such thing. And during that, Mr. Silvera would have known that he was the person who was responsible for her death. The post-mortem says she got 3 gunshot injuries. And he was even telling the police officer that as far as he knew, she had no known medical condition that would cause her to be in the state that she was found, which is all the more reason why the police officer should have been far more alert than he was. And I had conduct of the matter when it first came for trial in February. And I will never say that a defendant cannot exercise his right to have the prosecution case tested. I have no difficulty with that. I have no difficulty with seeking your own forensic services. I have no difficulty with that either. But the fact of the matter is that when the matter came up, the defendant wanted his own forensic person, and that's fine. But it's in a context where you knew what happened. You knew. And when the forensic legal professional privilege, I won't get into that, but the fact of the matter is that it seems to me that the effort here was directed to see if there was some room to maneuver regarding the ballistic evidence, because that was the anchor of the prosecution case. And then, after you had that opportunity, then the guilty plea came. So in other words, from December 2023, right up to February 2026, it was a state of denial, non-acceptance of responsibility. So that is going to inform how I view the plea of guilty. Context matters. So yes, you have accepted responsibility, but it seems to me that the acceptance came because of the quality of the work done by the Jamaican ballistic experts. And what is the expert saying? The expert is saying two things. One level of marking, you get the firearm category. Two, next level of marking, I keep using the word marking, matching, you get the specific firearm. And he's suggesting that what he saw in the barrel was not the result of the natural processes of corrosion and so on, but a deliberate effort. And he's also suggesting that the impact would be that bullets fired after the interference may be different in its markings and so on to facilitate identification, different from markings before the gun was fired. In other words, we can't be sure. So that's how I come to it. And September 29, 2023 is a significant date. It shows the value of proper processes. The value of proper processes is that the FLA did what it was supposed to do. You come to renew the license, give me your gun, let me look at it. Do I see any signs of tampering, corrosion, anything altering? Because one part of their responsibility is to keep signatures of all firearms of private citizens so that the very thing that has happened here, the police investigation can proceed and you identify the firearm. But the problem was, and here's the problem. The problem was the pathologist. She was the fly in the ointment because when the body was removed, death from some cause other than violence, and it was the pathologist came along and said, what? No. We're going to deal with this differently now. It was her alertness. And based upon all the evidence, but for her alertness and professionalism, we wouldn't be here now. So that is part of the context for me. So those are the aggravating factors. Why are those latter things aggravating to me? Because it suggested an effort now to disguise, to cover up, to escape. And the science put naught to that. And when you had your opportunity to have your expert examine, no wriggle room. The expert, the Jamaican expert, couldn't be discredited. So we are here. Now, on the positive side now, the mitigating factors, which must be taken into account. No previous conviction, clearly. Person of good character, as King's Counsel said, you were an elected representative. Some persons may believe that that is not necessarily a mark of distinction, but nonetheless, the electors of St. Mary found that you are a worthy person to represent, and that must be taken into account. There's no doubt about that. The evidence of your character witnesses, because as I've always said, if you have lived hitherto a previously good life, and when you get into difficulty, your good character cannot assist you, then what is the point? So yes, it has to be taken into account. The impact on the children, that is to say, the surviving parent will be away from the children for some time. That's a mitigating factor. The social inquiry report speaks positively about your work, your contribution, the relationship with your children, and by all accounts, you're an effective father. And by effective, I don't mean just like functioning like an ATM now, but presence, active involvement, all of those have to be taken into account. The victim impact statements, Council made reference to them, I looked at them. The jurisprudence suggests that they are not to be used as an aggravating factor, but to be taken into account in determining the initial categorization of the offense, but it's not supposed to have a decisive or impact to say the sentence goes up by a significant number of years, but it is factored into the process because there's always going to be a negative impact on those who are left behind. And it is not to be used to determine the level of sentencing ultimately. So it's taken into account. And as I said, and this is the difficulty in sentencing, there's no science that says aggravating factors mean you go up by 6 years, 7 years, or this particular factor is tied to a particular mathematical relationship. There's nothing like that. But nonetheless, it's a principle that we have to apply. And in my view, since I said the anchor point was 25 years, when you take into account the uplift as a result of the aggravating factors, I would say overall it goes up by roughly 6 years. The mitigating factors, it will come down by say, that will make it what, 31? From 25, the mitigating factors, you come down by say 4 years, that would leave it at 27. Now, Having done that, we go to the statute now, where you look at things like the guilty plea. I note the words of the prosecution, and I am not seeking to undermine the defendant's right to have counsel. And of course, clients are like patients of doctors. They can give the advice, but they may or may not follow it. And so counsel has to work with the client that he has. I am not saying anything one way or the other, but it's just the nature of the job. A lawyer can only advise, but the clients have to decide. And sometimes it takes a bit longer for some persons to get to that point than others. And counsel may very well point out all the rational arguments as to why they should do things at a particular time, but some clients just don't act in the way that they ought to. There's nothing the lawyer can do about that, but you still have to work with the material that you have. So counsel referred to the Criminal Justice Administration Act of 2015, where it says, pursuant to subsection 1, the court may reduce the sentence that it would otherwise have imposed on the defendant in the following manner, where the defendant indicates to the court on the first relevant day that he wishes to plead guilty to the offense, the sentence may be reduced by up to 50%. Well, I don't think we're at the first relevant date. Let's go to paragraph B, where the defendant indicates to the court after the first relevant date, but before the trial commences, that he wishes to plead guilty, the sentence may be reduced by up to 35%. I think could say that he fits in there somewhere, where the defendant pleads guilty to the offense after the commencement of the trial, clearly not there. So where we are is paragraph B, after the first relevant date and before the trial commences. It says may be reduced by up to 35%. Now, what this provision is designed to do is to incentivize guilty pleas. But I suspect, and this is something now for law reform and the legislation, when you have the pairing of the offenses here of manslaughter, which the judge has more this discretion there, with using a firearm, which is a mandatory minimum, then you wonder how does a defendant get the benefit of this? It's because if you plead guilty at the earth date, it's a minimum of 20 years, and if you plead 12 months later, it's still a minimum of 20 years. So that has to be taken into account as well, because there's really no benefit, really, for entering an early plea where you have a mandatory minimum of 20 years. So maybe the legislation should say something like, if he indicates on the first relevant date that he wishes to plead guilty, then notwithstanding the existence of a mandatory minimum, then the court can go below the minimum, because what you want to do is to incentivize persons to enter pleas rather than make it virtually pointless to enter a plea, since you are going to end up at more or less the same place, whether you go through a trial or you enter a plea. So I can understand those considerations. But nonetheless, he entered a plea, and it is of value. And I've indicated what that value is. So that should result in a further reduction. I don't think it's going to be as high as 35%, because of the context in which the guilty plea occurred, but nonetheless, it is a value. So, and in this particular case, had it gone to trial, quite likely the Crown would have had to call the children to give the evidence, and so that spared them the difficulty there, which is something that inures to his benefit. So, again, there is no precise mathematics here, but in the context of this case, I think that that is worth a further reduction of 4 years. That takes us down to 23. Not going to get into the percentage, but we're certainly not 35%. So that takes us now down to 23. This is in respect of count 2. Other factor is a question of remorse. It's one of those intangibles where is the guilty plea a reflection of remorse, or is it a tactical consideration? Well, I have indicated my position on that, and it seems to have been a tactical consideration rather than remorse. Though I acknowledge that he said in the social inquiry report that he's remorseful on all of those things, but having regard to the broader context, I think it was more strategic than remorse. But nonetheless, it's a guilty plea. Nonetheless, he has been in custody for 2 years plus, so that's 2 years from 23 and 16 days. Yes. Okay, let's call it 20 is what, 25, 26 months? Let's call it 26 months, 2 years down from 23, that makes it what, 21, and then you take out the 2 months, so that's 20 and 10 months. And I'm just checking to see if there's anything else that I need to bear in mind in terms of mitigating factors and their impact. And that seems to be it. I think that is it. Right. So, in terms of count 2, we are at 20 years, 10 months, and that's the time for count 2. In respect of count 1, well, I'm just a trial judge. I am not at liberty to ignore the words of the parliamentarians, and they have indicated that there is a minimum and a maximum, and they have indicated that the minimum is 20 years, maximum is 25. So again, a guilty plea is of inherent value, whether it shows remorse or not. At least that's my view. And so I can't go below what Parliament has said. I know Mr. Champagne has referred me to the decision from the Privy Council, but they are the Privy Council. So I think that it would be improper of me to do that, not because counsel is inherently wrong, but I think it is something that deserves full argument, that all the circumstances surrounding the legislation and so on, and all the relevant case law has been examined. It's very difficult to do that in the context of sentencing, and unless it's a clear authority from our Court of Appeal or the Privy Council to that effect. So on respect of count 1, sir, sentence is 20 years at a minimum. So the other principle of sentencing is that sentences arising out of, offenses arising out of the same factual circumstances are to run concurrently unless there is some good reason not to do so. There is no good reason not to do so in this case. So both offenses, sentences on both offenses, count 1 and count 2, are to run concurrently. So it's 20 years on count 1, 20 years, 10 months on count 2. And so we are now happily at the end of this process. So let me again thank counsel for the Crown and counsel for the defense for the work that they have done, and again to recognize the significant work done by my judicial counsel, who at times I gave him things to do at very short notice. I know that he was up late at night doing the research, so I thank him again. So he has enabled me to be here this morning to do this. And just again, a gentle reminder to the media, please do your reports in a manner that the persons, witnesses, or otherwise can be identified. Okay? So that's it then. So let's adjourn.
Stand, please.
Yes? Should be stated. Oh. Okay, let's all sit, have a seat. Yes.
In relation, my lord, to section
101
indeed, my lord,
of the
Firearms Act.
new act.
Indeed, so, my lord.
Yes.
Subsection 8, my lord,
101.
and paragraph B, my lord.
101 section
8, my lord, paragraph B.
Okay. Okay. So I'm being reminded here that section 101 of the Firearms Prohibition, Restriction and Regulation Act says, among other things, 101 subsection 8 says, unless otherwise specifically provided in this act, the penalty provided for an offense against this act is life imprisonment, notwithstanding anything in the act, the court shall specify a term of not less than 15 years that the offender shall serve before being eligible for parole. Well, that doesn't apply since the sentence for 14(2) is not life. And it says the alternative now is where there's a prescribed minimum, notwithstanding anything in the Parole Act, the court shall specify a term of not less than 10 years that the offender shall serve before being eligible for parole. So I need to specify a term. Oh, well, okay. So anything on this, you have to give counsel a chance to be heard here, though.
Well, my lord, given the context in which, in terms of the plea, I would invite the court to invoke the minimum, my lord.
Very well. Subsection 2 of the legislation prescribes a minimum period of 20 years, and section 101, subsection 8 indicates that notwithstanding the Parole Act, the court shall specify a term of not less than 10 years that the offender shall serve before becoming eligible for parole. Now, well, clearly, I think in principle, the minimum, well, it sets a floor that you can't go below 10 years. So it now means that you have to go somewhere between 10 and the 20 years. The further context is this. The purpose of parole is to encourage good behavior. That's really it. So persons who behave well and are an asset and a credit to the institution while they are there should be able to use that as a basis for earlier release than if they were recalcitrants there. So it is really an incentive for the rehabilitation process. Now, it seems to me in principle, the difference between the stated sentence and the parole eligibility period should be sufficiently wide to incentivize good behavior, because if I were to say 17 years, then I mean, really, what's the point? So I think that having regard to the fact that this felony resulted in a death, it should be higher than the 10 years, because offenses other than death are at 10 years. So I don't think both of them in principle should be the same. But the question is how far up? So again, no science here. So it must be sufficiently wide to be meaningful. And so that is what I'm going to do, and suggest that the minimum period before becoming eligible for parole in respect of count 1 should be 13 years.
I didn't hear Lordship.
13.
13, thank you.
13, 1, 3. Yes. So I think I've covered everything now, I hope. Yes. Thank you all very much. Let's say the adjournment, please.
Stand, please. This honorable court now stands adjourned. God save the King.
For joining us for the live stream in the matter of the King against Julian Silvera. We encourage you to follow us on our social media platforms.